but thank you for in fact giving us this time. Now it's time to shift our focus to other developments. The government has released the long-awaited draft of digital personal data protection rules, which specify that parents' verifiable consent will have to be obtained by social media or online platforms before children can create any accounts on the social media. Further, parents have also be required to submit their identity, and age will also have to be validated and thoroughly confirmed while being through voluntarily provided identity proofs issued by the entity entrusted by law or the government as per the draft rules. This is in fact what are the basic amendments for the digital personal data protection rules. Let me firstly put out the basic features of this in fact draft. Firstly, the feature of consent takes place the spotlight. Verifiable parent consent is mandatory here, which means that before processing the contents and making a social media account for a child, the parental consent is going to be mandatory for that first step, which in fact right now many children do classify, do in fact enter the age of being an adult as considered to be 18, but they are in reality much younger. If we move ahead, in fact, under the garb of the consent category and the amendment bill, this includes the verification of the parent's identity and the proofs supporting the identity of the parents. Now, the third one is the data retention and deletion. Now, personal data must be retained only for the duration necessary for creating the purpose of which has been collected. The personal data will not be collected and then used further. It is what the draft rules also mention specifically. For those in fact who object to these draft rules, this is a very important point. Then there is obligation to delete the data when the use is over, once the purpose is fulfilled with the expectations. Data can be retained for up to 3 years from the last interaction. The 3 years window has been in fact given for the person or the consumer to retain the data. Now, the data breach and notification is also an important one. This is another feature, obligation to delete the data once purpose is fulfilled. That is in fact what we have already covered. If we just go to the next one being placed here, that the data breach and obligation has been done. In fact, 3 years is what the time has been given. Data fiduciaries are required to notify the individuals and data protection board of a breach within 72 hours. If there are any kind of obligations that in fact are found, there are violations up till a video of time of 72 hours, these can be notified. Draft rules open to the public feedback till February 18th this year on the My Government portal is what in fact going to be a big game changer into how the Personalized Digital Data Protection Act looked like. In fact, right now what importantly needs to be looked at this point of time is how this is going to frame the rules over which children access the contents of the social media. Gautam Mukherjee, senior journalist, joins me for more. Sir, appreciate you joining me live and thank you for speaking to us. Right now, when we are talking about digital personal data protection draft rules 2025, till 18th of February, there are going to be many considerations, even from the consumers, the people who are accessing social media and parents who specifically have children whose accounts have to be put there for in fact their consent as well. And there are many parents right now as well who are using children and managing their account for content creation on social media. So when we are talking about this present scenario, how does this digital Personal Data Protection Act is going to bring a change in that regard?
Well, from what you've just said, it looks like it's quite a liberal setup. 3 years is quite enough, and we have to actually watch to see how the act is implemented and what its effects are before we can fine-tune it. But for the moment, it looks pretty good to me.
But in the cases of where parents are accessing the social media accounts of the children for the purpose of content creation, how do you think the draft rules are going to bring up a change in that regard?
You know, it's all on the edge of the concept of privacy. And so if other people are, including parents, are accessing their children's accounts, then that is something that has to be looked at through the prism of privacy. But the rule as such has to be broader than that, and I think it's attempting to do just that.
All right. Gautam Mukherjee, thank you for in fact speaking to us and giving us your time. On that note, viewers, that was all the news of the nation and the world. We'll continue to track all the developments very closely after a break.